Due Process, awarded 9 Emmys, including the 2005 New York Emmy for Outstanding Crime Reporting Programming.
Please be seated.
There's a new Chief Justice on the state Supreme Court, but he'll only be there till June. That's when he'll turn 70, and like the last chief, he'll be forced to resign. What to expect in the meantime from the leader of a court that has just made history. That's next on this edition of Due Process.
Major funding for Due Process provided by the New Jersey State Bar Foundation, committed to educating the public about the law, and by the Fund for New Jersey, supporting informed citizens for an effective democracy. Additional funding provided by Lawyer's Diary and Manual and online legal reference, elaw.com.
It's a court that's been known for its bold decisions from Abbott to Mount Laurel. But with its decision on gay unions, the New Jersey Supreme Court drew new praise and new condemnation. The ruling came on the final day for Chief Justice Deborah Poritz, and that means there's now a new chief. I'm Raymond Brown, and on this edition of Due Process, a new justice, a new chief in Jim Zazzali, a new court. So what can we expect from a Zazzali court? We'll get some very different takes from an expert panel, but first, Sandy King is here to bring us up to date.
Raymond Jim Zazzali has a long, strong history of state public service, from Attorney General to chair of the SCI, and now just the 7th Chief Justice in nearly 60 years. But unlike all those long-tenured chiefs, Zazzali won't be around for long. But he says, don't call him just a caretaker.
Please be seated.
It was his first day as Chief Justice, the court hearing an issue of evidence allowed in the retrial of former NBA star Jason Williams. The start of what will be just an 8-month term, because Jim Zazzali will turn 70, the mandatory retirement age, in June.
Good morning, ladies and gentlemen. The first matter this morning is State v. Jason Williams.
And like his predecessor, Deborah Poritz, Zazzali will be forced to resign.
We can then deliver this to our successor, this court, in the same mint condition that we received it from Chief Justice Poritz.
Though maybe not with as much of a bang as Chief Poritz, whose last day brought a groundbreaking ruling on gay marriage.
I have to thank the court very much for the fact that they realized, they got the fact that we were being discriminated against, and it was a case of true discrimination. We're the only group of people in the United States that still feel it, and it's time it ends.
The majority ruled that gays are entitled to all the rights and responsibilities of marriage, but stopped short of using the M word.
What is now the legitimate government objective in not permitting gay people to marry?
So Poritz wrote a strong dissent, insisting that the court should have gone further. The only equitable word, she wrote, is marriage.
It's not as if, however, that fundamental institution hasn't changed with time in rather dramatic ways.
And Justice Zazzali, who heard the case with her back in February, signed on to her dissent.
But following up on the Chief Justice's question, referring generally to the changes in our society in the last 60 years, what has changed more than the institution of marriage? In so many profound ways, and some would argue in so many negative ways. And you can't blame the gay rights movement on those material changes to the institution.
And he's making no apologies. At his ceremonial swearing-in last week, Zazzali said the court's guilty not of judicial activism, but of justice.
Like life itself, justice is a journey. My primary responsibility on the trip, with the help of these magnificent colleagues, is to maintain this court's tradition of excellence.
But Zazzali knows he's taken the gavel at a time when court critics are especially enraged by the ruling on gay couples. One assemblyman's even called for the impeachment of all the justices, including the chief. Still, Zazzali seems determined to make his mark, even, Raymond, if he only has 8 months to do it.
And when we come back, we'll hear from one of the court's legislative critics and from 2 professors of civil rights and constitutional law. So stay with us.
Supreme Court Justice in New Jersey? I have no clue.
I forgot. He just got appointed too. It's a new guy. I forgot his name.
I can't think of his name. How embarrassing is that? New Jersey? No clue.
Of New Jersey? No, I don't.
Good question. And I work for the courts. I'm going to get so fired.
No, I really don't, I'll be honest with you.
Oh boy. I have no idea.
Yeah, Zazzali.
I don't know. I forgot.
Of New Jersey?
Hey, Dave, hold on one sec. Zazzali.
So most New Jerseyans may have no clue who's on the court, but what that court does impacts all of our lives. And that's one thing on which all our guests can likely agree. They are Morris County Assemblyman Michael Patrick Carroll, Rutgers Law School professor and ACLU General Counsel Frank Askin, and in Newark, Seton Hall Law professor Shavar Jeffries. Thank you all for joining us. A gay marriage decision that I suspect you don't like, and then somebody in the dissent, a stronger view, Zazzali, appointed Chief Justice. When it rains, it pours, from your point of view.
Our Supreme Court has been an embarrassment for probably 40 years, and probably the one thing that Zazzali has going for them is he can't possibly be as bad as his 2 predecessors because he won't be there as long. And, I mean, whether it's gay marriage, whether it's Abbott versus Burke, whether it's right to choose versus Byrne, whether it's Mount Laurel, whether it's redistricting, whether it's Torricelli, the court routinely does what it bloody well pleases without regard to what the law actually says. Well,
a colleague of yours from Morris County has asked people to support him in impeaching all the justices, including Zazzali. Are you with that movement or not?
No, because I will exclude Helen Hones, because she's only been up there for 15 minutes.
The rest,
I mean, again, I think that the important part of being a judge is understanding that you don't have the right to throw your own personal policy predilections into the Constitution. Judge Skillman said it precisely correctly in the Pierce decision in the Appellate Division. And when a judge does what happened there, which is in effect say, we know the Constitution doesn't include this, it wasn't included in the intentions of the people who wrote or ratified it, but we're going to do it anyway. What you have demonstrated is that you're unqualified to be a judge.
Frank Askin, we've had a thumbnail sketch of a critique of our court. Right. Your response?
I think it is the most celebrated and best court in the entire country, and has been for many, many years, and will continue to be. From Vanderbilt Court through Hughes and Lentz and Poritz, and even for the brief moment of Zazzali, I think it will remain an extraordinary court which is committed to justice and equality, which is as much as you can ask of any court to be.
Shavar, surprised that there is at least talk of impeachment, even with the qualified support of our guest?
I'm very surprised to hear that, and I don't think the rhetoric of the sort that the Assemblyman just provided is useful or helpful to public respect for the work of the court. We may disagree individually and politically with some of the outcomes reached by the court, but to suggest that...
What part of his critique do you think is bad for the court, as opposed to just part of our general discourse about the law?
Well, I think the suggestion that justices should be impeached for what they've done, for example, in the gay marriage case, or more substantively, the suggestion that the judges just willfully disregard the law and seek to vindicate their own personal, private interests as justices is not useful at all. I think, for example, in the gay marriage case, however one feels about the substance of the decision, at the end of the day, the state really articulated no meaningful justification for why the state should continue to discriminate in this way. In fact, the state simply said defer to the legislature. And when we have a constitution, courts cannot do that. They need to adjudicate constitutional claims. If the state had come forward with a more substantive basis and folks just disagreed with the court's analysis of that basis, that might be one thing. But the court really articulated no reason, which is why the New Jersey Supreme Court unanimously held that gay couples were entitled to these benefits. Obviously, the court differed in terms of whether or not they'd be entitled to the label.
Let me come back to Michael Patrick Carroll. Here's an interesting question. An 8-month tenure, even though Chief Justice Zazzali says he's not a caretaker, seems interesting. There's got to be a political explanation for that, and you as a political, sophisticated person have got to be able to give us the answer.
Well, everybody assumes that it was just simply a caretaker until you had a situation where the chief was going to resign, and technically speaking, the appointment, that if that was a vacancy, was supposed to go to a Republican under our system. So we appointed Zazzali as a caretaker. When Zazzali retires, everybody assumes that Justice Albin will move up.
Oh, has there not been some thought about the new Attorney General?
No, I'm sure that there's lots of thoughts about that, but that's what we've been told.
Frank, is there any way... Oh, I'm sorry, go ahead.
Go ahead. No, go ahead.
Is there any way that in an 8-month tenure, essentially one term, a Chief Justice who follows two giant Chief Justices, whether you think they're bad giants or whether you think they're giants in a progressive sense, is there any way that in an 8-month tenure, Zazzali can make any mark on this court?
I think it'll be difficult. I happen to think Jim Zazzali is an extraordinarily terrific public servant, and it is a fitting capstone to an extraordinary career of public service for Jim Zazzali to have this honor, at least for 8 months. He can have much of an impact. I believe the court will continue the path that it's been on for many, many years. Zazzali still only has one vote. He has the same vote as Chief Justice he had as Associate Justice. The new person in the picture is Justice Holmes. And I think she will be very much in the tradition of Chief Justice Porritt's. I think she will vote probably fairly similarly.
Well, let me ask you this question, Frank.
Yeah.
Do we measure a Chief Justice by the Chief's capacity to deliver majorities for opinions they think right? Or, for example, in this case, Justice Porras was in the dissent in the gay marriage decision, but it's hard not to see that the decision overall will still be seen as part of her legacy.
Oh, absolutely. I happen to think, my own personal opinion was that Lewis v. Harris had probably the best possible outcome. It was a unanimous decision, which I think was awfully important, that gays must have all the rights of heterosexual couples. I think this was an important statement from an important court to be unanimous. At the same time, you had a powerful 3-justice dissent that says, and we ought to go a little bit further. And that's probably the wave of the future.
I take it you dissent.
Well, of course. I mean, you know, even in Massachusetts, they had 3 dissenters of judges who were actually saying that the court has gone too far. In our situation, we had a 4-3 decision in which the 3 dissenters were saying the nutty decision wasn't nutty enough. And, you know, again, going back to the point that I think Professor Shavar raised before, the fact of the matter is that judges are confined not to doing justice, but to doing what the law tells them they have to do.
But you had Republicans in both New Jersey and Massachusetts in favor of a position that at least a sizable number of Republicans are opposed to. Wouldn't that suggest that they were actually analyses of legal positions and not ideological expressions?
The answer, I would love to believe that were in fact the case. But the fact is, I read Judge Skillman's cogent and comprehensive opinion in the appellate division, and he put it very clearly. It says that this is not in the Constitution. We can't simply take one particular provision of the Constitution and interpret it to meet our particular policy predilections. And that's what happened.
Can I jump in here?
Go ahead, good. Shavar, jump in there.
It seems to me if we have an equal protection clause in the state constitution, which we do, and the courts have interpreted the state constitution to provide an equal protection entitlement, the state needs to come forward with a reasonable justification for discriminating against classes of people. The state
do
did
I understand,
not do
Shavar, that your critique is less a wholehearted support for the opinion than a criticism of the state's failure to articulate a basis for an alternate result?
Absolutely. My personal view, I think, in terms of what the political outcome should be, I think is irrelevant to how a judge should go about their legal jurisprudential function of finding a law in an individual case. In this case, the state did not come forward with any of the various rationales in terms of child rearing that we've seen in other contexts to justify this discrimination. The state essentially said, defer to the legislature. And courts cannot do that with constitutional claims. And I think that's primarily why we had a unanimous decision, which I think is the first state Supreme Court in the country country to unanimously hold that same-sex couples were entitled to all of the substantive incidents of marriage. So I really have a strong criticism of the Assemblyman's contention that the court in this case, however one may feel politically about the outcome, operated in a kind of ultra-vires fashion.
Frank, one more, and then we're going to move past
Yeah,
this.
I think one of the most extraordinary aspects of this decision was the three dissenters who took the most far-out position were all appointed by a Republican governor.
Does that undercut
appointees.
your view, Assemblyman, that it's an ideological?
I've never suggested it was a partisan matter. I mean, the court has gotten it wrong under Republicans and Democrats alike. I mean, you know, you look at the worst justices in the United States Supreme Court, Souter and Stevens, were also appointed by Republicans. Again, the whole question comes down to a simple matter of judicial interpretation of the law as opposed to imposing their particular viewpoints.
This is the last question on this subject, but I got to ask you this. Do you, in the opposition, have any other options in the legislature but to provide within the 180 days or shortly thereafter some civil union statute comments?
Of course. I mean, the legislature could always feel its Wheaties for a change and decide to tell the court that it's made its decision, let it go enforce it.
Do you see that as a possibility?
I don't.
Would you advocate that?
I would. I think under certain circumstances, the legislature must assert its constitutional prerogative.
So, Shavar, what the Assembly seems to be saying is that a possible position here would be for the legislature to defy the court.
And I think, frankly, that suggests that the legislature has no respect for the rule of law. That sounds like a Cooper v. Aaron situation where states, and that was at post-Brown, where states decided to simply flaunt the clear mandate of the court in Brown. The bottom line is, however you feel politically about the decision, it's been made.
Right. Now, Frank,
and for the legislature to simply defy that, I think shows a disrespect for the rule of law.
Now, Frank, this would give us a scenario in which Zazzali might, in a very short time, have a legacy-producing decision.
Well,
suppose the legislature did follow the lead of Assemblyman Carroll and said, we will not pass a statutory scheme commensurate with the opinion. What happens then? And would Zazzali be the leader of a court that would take seriously this precedent?
Well, of course, that's not going to happen.
Right,
it's very speculative.
Well, you can never underestimate Assemblyman Carroll's power.
That's right.
But yeah, I suppose that's possible. The court would merely, and they'll enforce their own ruling, and they'll decide what to call it, whether to call it a civil union or marriage.
Then assuming that Assemblyman Carroll doesn't sway his colleagues in that way, can you see any case ahead on the docket for this term that might give Justice Zazzali some opportunity to come at an issue that's profound and controversial? Maybe not Abbott, Mount Laurel, or gay marriage, but something.
Well, I have a case before the court this term. It's
must be earth-shaking.
Which is very important. It has to do with whether or not New Jersey community associations, which now are home to more than 1 million people in New Jersey, are constitutional actors or not, and must respect the fundamental rights of the residents of those communities. It's a case which we won in the appellate division. The defendants and the community associations have taken it to the Supreme Court. It's going to be an important decision.
Shavar, is that case the stuff of which legacies are made, even if you got a one term as a Chief Justice?
I tend to be skeptical as to whether or not, given the tradition of the New Jersey Supreme Court in matters of broad statewide and national importance in terms of educational rights, in terms of the housing rights in the Mount Laurel case, as significant as that decision is that Frank just described, I don't think that's the sort of stuff that a legacy is made of.
So do you see anything on the docket, same question I asked Frank, that might give Zazzali the opportunity to shape an issue, maybe not quite at Abbott, Mount Laurel, gay marriage level, but maybe one notch below, but still a powerful legacy producing, where we have to debate it at least?
Ray, frankly, I don't see anything on the docket over the next 8 months that will allow Zazzali to really materially advance the law in any meaningful way. I tend to agree, frankly, with the Assemblyman that it seems to me there's political motivations as to why we have a kind of caretaker acting Chief Justice as opposed to someone who could fill that slot in the longer term.
I mean, one possibility, it's probably a long shot, is that the legislature in its tax reform package does something which might undermine Abbott v. Burke, and that the Educational Law Center and the school committee might go back to the Supreme Court to challenge what the legislature has done.
And
that's
that might have certainly
important.
controversy because there are strong feelings both sides of that question.
He and I discussed that beforehand, and the fact is that if they do, in fact, follow through on their property tax proposals, which would, in effect, quasi-repeal Abbott, and instead of going to districts, gives money to kids, or along those lines, that undercuts the basis of Abbott. And if that happens, obviously, the Supremes may take a different view of what policy requires.
So there is one possibility in terms of our long-standing Abbott controversy. Let me throw out something that probably reflects some popular interest and also interest on the part of the criminal defense bar, but may not have the same kind of resonance more broadly, and that's the Jason Williams issues, the issues that came there. There certainly has been public attention riveted on the court, which starkly contrasts with, for example, folks who don't even know who's on the court, so that you would have public attention riveted on a question that's important in the criminal realm. Is propensity, that is the fact, can you be tried for being a bad guy, or is it possible for certain kinds of evidence to come in? Shavar, is that a case that might at least have some public resonance and force people to look at the court in a way that they don't ordinarily?
I think it's useful in the sense that hopefully it can get the court, it can get the public to realize that most of the work the court does is decide claims of this sort, which while this claim may have some public resonance, is much more legalistic and narrow in focus. And I think that's very important in a context in which the court is so consistently under political attack of the sort that the Assemblyman has articulated. I think it's very important, however one feels about the outcomes of the court in individual cases, that we ensure that the public has respect for the role of the court in our constitutional system and for the integrity of our justices, despite the fact that we may disagree with them on individual matters.
My sense is, Frank, that you see that as a case that have more popular appeal than resonance as a legal opinion?
Yeah, I think that that's probably too fact-based and probably will not have a significant legal impact. It'll go off on some factual aspects of the case. But although this court is very unpredictable in the criminal law area, I think it's very predictable in civil, constitutional, individual rights, protection of individual rights, general due process. But on criminal prosecutions, this court's pretty well divided, and it's hard to predict. For example, Zazzali, who is really a very, I think, progressive, social justice-oriented judge, is a former prosecutor. And he's never expressed a lot of sympathy for malefactors and criminal wrongdoers.
Let me ask you something, whether he agrees with your characterization as a court or Chief Justice Zazzali as not being especially progressive in the realm of defense of criminal defendants.
Well, we may find out about that because I understand they just took a case or heard a case on the right of silence. Right. 3 joint cases as to whether or not, when does the right to remain silent, what can the prosecutor do?
When can a prosecutor comment
on a person's
silence?
refusal to come forward? Does it only attach after Miranda? I mean, those may sound like legalistic rights, but if they come out in favor of providing a blanket right to silence even before Miranda cuts in, that could have a very substantial impact.
That is a case on the docket for this term. What would you expect from a Zazzali-led court in light of Frank's characterization of the chief as fairly conservative on criminal justice?
Again, I think the professors are probably correct on that one. Is that there's not a lot of room for creative constitutionalism on those sorts of things, and it's entirely possible they might actually read the document.
But let me throw another wrinkle in the general assessment of the criminal jurisprudence of this court. One could argue that this court, taken back really 2 justices, has deftly kept the death penalty in the air while no one is executed until such time as the legislature gets worn out. So in that sense, there has been the suggestion, at least on maybe the premier public policy criminal justice issue, a court that's been subtly abolitionist. Professor Shavar, what do you think about that?
I think there's some merit to that. New Jersey does have one of the more robust systems of review in terms of death penalty appeals, and I of course think that that's a good thing. Anytime the state is going to take the life of a citizen, we need to ensure that that decision is justified, that individual in fact committed the crime he or she has been charged with. And I do think, Ray, there's a lot of merit in your premise because it does seem as if the New Jersey Supreme Court is trying to kind of run out the clock on the death penalty until the legislature steps in and revisits the question.
Now, on the condition that you will come back when the next Chief Justice is named, we will ask from each of you your prediction as to the next Chief Justice. I think you already said it was going to be Albin, but I'll give you a chance to recant and do Rabin.
No, it's entirely possible. Who knows? If McGreevey were still in office, it's clear it would have been Albin. I mean, I think that was everybody's understanding. understanding.
But you got to commit so we can bring you back and jump up and down and scream if you're wrong.
If I were a betting man, that would be my bet.
My dark horse candidate is New Jersey Public Advocate Ronald Chen.
Wow, we're going to have a good show. Shavar?
I would guess Albin. I wouldn't be surprised to see Chief Justice Rabner. I'd love to see Chief Justice Larry Lussberg in my own personal view.
Shavar, you've been out there. It's a good thing you're in Newark. There's a different air up there. But those are interesting guests, and I'm sure that's going to give us a lot to talk about when we come back. Are we going to be surprised by anything that happens in this next term? Anything that you can imagine that's a dark horse as an issue that we haven't talked about?
No, this court, I'll tell you this, is that as the one thing, I'm not entirely certain that the presser's right on this court being unpredictable. When Bill Baroni argued the Torricelli case, he said everybody out of state always told him he couldn't possibly lose, and everybody in state said he couldn't possibly win. This court is very predictable with its outcomes.
Except that it's unpredictable. But on that note, we got to end, but you're all coming back soon with my thanks to Professor Frank Askin, to Professor Jeffries, and to Assemblyman Michael Patrick Carroll. That's it for this edition of Due Process, but we hope you'll join us next week and every week. Till then, for Sandy King and all of us here, I'm Raymond Brown. Thank you for watching.
He rules clearly and consistently, and I'm confident he will provide exemplary leadership in the court and continue its tradition of excellence.
Faithfully, impartially, and justly, to the best of my ability, so help me God.
So help me God. My dedication to the goal, a goal which is preeminent with you, that we work together, the three branches of government, to preserve, protect, and advance the rights and the interests of the good people of our state.
Major funding for Due Process provided by the New Jersey State Bar Foundation, committed to educating the public about the law, and by the Fund for New Jersey, supporting informed citizens for an effective democracy. Additional funding provided by Lawyer's Diary and Manual and online legal reference, elaw.com.